This interview is a reconstruction created for educational purposes. Names and characters are fictional. AI technology was used to generate parts of this content. This video does not provide legal advice. For guidance on your specific situation, please consult a licensed attorney.
Welcome back to Legal Matters Radio. I'm your host, Sarah, and today we're diving into an area of California law that affects both property owners and visitors: premises liability. Joining us is Professor James Whitfield, a distinguished scholar of tort law. Professor, thanks for being here.
Thanks for having me, Sarah. Always glad to talk about how the law applies to everyday situations.
Let's start at the beginning. When we talk about premises liability in California, what does that actually mean?
Premises liability is essentially a type of negligence claim that arises when someone is harmed because of the way a property was owned, occupied, or maintained. The law says if you're bringing a premises liability lawsuit, you need to prove 4 essential elements.
And what are those 4?
First, the defendant must have owned, leased, occupied, or controlled the property. Control is key. You don't need to own it, but if you had the right to manage or control the conditions, that's enough. Second, the plaintiff has to show that the defendant was negligent in the use or maintenance of the property. That means failing to act as a reasonable property manager would. Third, there has to be actual harm suffered by the plaintiff. And finally, the plaintiff must prove that the defendant's negligence was a substantial factor in causing that harm. In other words, the unsafe condition and the property owner's failure to address it must be tied directly to the injury.
So it's not enough that someone got hurt on the property. You have to connect that harm to negligent management of the property itself.
Exactly. An injury alone doesn't automatically mean liability.
Now, you mentioned negligence. That brings us to the duty of care. What's expected of property owners in California?
The law says that anyone who owns, leases, occupies, or controls property must use reasonable care to keep it in a reasonably safe condition. That duty includes discovering unsafe conditions and then repairing them, replacing dangerous features, or at least giving adequate warnings.
That sounds broad. How do courts decide if someone actually used reasonable care?
They look at a variety of factors. For example, the location of the property, the likelihood someone would enter the property the way the injured person did, the likelihood and seriousness of harm, whether the property owner knew or should have known of the condition, how difficult it would have been to protect against the harm, and the degree of control the defendant had over the dangerous condition.
So if a store owner knows about a broken step and ignores it, that's very different from a danger they truly couldn't have discovered.
That's right. Knowledge, whether actual or what a reasonable person should have known, plays a huge role.
What about cases where the property owner hires someone else to take care of maintenance?
That's a great question. Under what's called the Nondelegable duty doctrine, a property owner cannot escape liability by saying, well, I hired an independent contractor. If the property isn't kept reasonably safe, the owner is still responsible, even if the unsafe condition was caused by the contractor's negligence.
That puts a lot of responsibility squarely on the person in control of the property. But the law also doesn't expect perfection, right?
Correct. Property owners are not insurers of everyone's safety. There's something called the trivial defect doctrine. For example, if there's a very small, minor irregularity in a walkway, the law recognizes that owners can't be expected to maintain absolutely flawless conditions. The question is whether a condition poses an unreasonable risk of harm.
That seems fair. Now, does the duty of care extend beyond the boundaries of the property?
Interestingly, yes. If a property is maintained in such a way that it exposes people to an unreasonable risk of harm off-site, the duty of care can extend beyond the property line. Imagine, for instance, debris from a property creating hazards on a public sidewalk.
So the law looks at the real-world consequences of how a property is managed, not just the four corners of the property itself.
Exactly. The guiding principle is, did the property owner act reasonably in view of the foreseeable risk of injury to others?
One last question. Does the purpose of someone's visit to the property, whether they're a guest, a customer, or even trespassing, still matter under California law?
Historically, the law made strict distinctions between invitees, licensees, and trespassers. California has moved away from those rigid categories. Now the focus is on general negligence principles. That said, the reason someone is on the property can still be considered as one factor in determining what risks were foreseeable and whether precautions were reasonable.
Professor, this has been incredibly informative. Premises liability clearly places significant duties on property owners, but also balances those duties with what's reasonable under the circumstances.
That's a good summary. The law is designed to encourage safe property management without imposing impossible standards.
Thank you again for joining us today.
My pleasure, Sarah.
And that wraps up today's episode of Legal Matters Radio. If you've ever wondered about your rights as a property owner or as someone injured on another's property, now you know the framework the courts will look at here in California. Remember, this discussion is for educational purposes only and not legal advice. Please consult with an attorney about your specific situation. Thanks for listening.
Question 1. Which of the following is sufficient for a defendant to be liable under California premises liability law? A. Owning the property only. B. Controlling the property only. C. Either owning, leasing, occupying, or controlling the property. D. Simply being present on the property. Correct answer, C. Either owning, leasing, occupying, or controlling the property. Question 2. What must a plaintiff prove to establish that a property owner was negligent? A. The owner had a minor defect on the property. B. The property owner failed to act as a reasonable property manager would. C. The property was old or poorly designed. D. Someone was injured regardless of cause. Correct answer, B. The property owner failed to act as a reasonable property manager would. Question 3. Which doctrine states that a property owner cannot escape liability by hiring an independent contractor? A. Trivial defect doctrine. B. Invitee, licensee, trespasser doctrine. C. Nondelegable duty doctrine. D. Reasonable care doctrine. Correct answer, C. Nondelegable duty doctrine.